So we have some very important updates and developments in the critical assault weapon and magazine ban challenges that are seeking Supreme Court review. Now, before we jump into this video, I just want to mention that looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. Also, click the notification bell and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. Now, as I mentioned in the intro, in this video, we're going to be talking about some very important developments and updates in a couple cases that are challenging various state bans on so-called assault weapons and then also magazine ban restrictions as well. These cases we're going to be talking about are the Snope versus Brown case, which is a Maryland challenge to their ban on so-called assault weapons, simply their rifle ban, and then also Ocean State Tactical, which deals with Rhode Island's ban on magazines that hold more than 10 rounds. Now, these two cases have been, in the news. We've been keeping our eyes on these because the Supreme Court was asked to grant review to these cases. These cases were relisted multiple times. Recently, they went to conference last Friday, and then today we got the order list from the Supreme Court, and unfortunately, they have relisted these cases once again. That means that this term, at least we know that the Supreme Court will not be hearing and deciding a rifle or magazine ban case. So at least for this term, it means that we will not get a hearing and decision on a rifle ban or magazine ban at least before June, July of this year. However, not all hope is lost with these cases. I know some people are going to say that this is absolutely detrimental to these cases. And in some ways, we do have a signal that maybe bad things could be coming in these cases. However, not all hope is lost in these cases. These cases have not been denied review at this point. They will now be relisted for another conference, which could be a bad sign, but there is also still an outside chance that review could be granted in these cases based on prior 2A track records and similar multiple relists that happen in other 2A cases. So we need to talk about what is happening and what is the potential outcome of what just happened with the order list. Now, for those not aware, the Snope case is kind of the biggest case out of all of these because it deals with a state's ban on so-called assault weapons, which was prior GVR, meaning that it was granted, vacated, and remanded by the Supreme Court after Bruen. So this Snope case is a case that the Supreme Court is very familiar with. They GVR'd prior because of Bruen, and they've had this in front of them a couple times. So again, it's a final merits case that the Supreme Court is familiar with. Now, this case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore banning them within the state. The ban was challenged in a Maryland federal district court. However, this case was dismissed by the lower court because there was already a case on the books in the federal courts there that found that the Maryland ban here did not violate the Second Amendment. Now, that dismissal in that case was then appealed to the Fourth Circuit, and a 3-judge panel in the Fourth Circuit again upheld that dismissal. And that then led this case for the first time to go to the Supreme Court back in 2022, and they sought Supreme Court review and reversal of this issue. Now, the Supreme Court ultimately ruled in the landmark Second Amendment case, New York State Rifle and Pistol Association versus Bruen, and the Bianchi case was then, as a result of that, granted, vacated, and remanded back down to the Fourth Circuit for a new decision in light of Bruen. The Fourth Circuit en banc panel then issued their decision after many months, and then again they upheld the Maryland rifle ban and found that it was constitutional. Now, in that decision, the Fourth Circuit upheld the state's ban using the incorrect military use test. Essentially, the Fourth Circuit believed that AR-15s are useful in military service, and therefore they could just outright ban them. And as a result of that very horrible decision, the Snope case has now made its way once again back up to Supreme Court. Now, the Snope case was originally set to be heard by the Supreme Court to go to conference back in December 13th, but then it was rescheduled, which is different from a relist. It was rescheduled, and then it was set for conference on January 10th. Now, then after January 10th, it was relisted for January 17th, and then after January 17th, it was relisted for January 24th. And then this Monday, now we received an order list, and the Snope case and also the Ocean State Tactical case, which we're going to talk about here in a little bit, we're not on the order list. There was no grant or denial of those cases, which means they're likely going to be relisted for the next conference in the Supreme Court. And according to the Supreme Court's calendar right now, the next conference date is actually February 21st. Now, the other case, which is again very important, is kind of going through the same process, is the Ocean State Tactical case, which deals with the state of Rhode Island's ban on magazines. Now, this also deals with a lower court's denial of a preliminary injunction, which is different from the final merits decision that's going on in the Snope case. Now, Ocean State Tactical was also relisted multiple times, and most recently, again, in the order list, there was not a grant or denial of this case, so it's going to be relisted once again with the Snope case for the upcoming future conference. Now, you may be asking yourself, why is the Supreme Court relisting a case multiple times so important? What does a relist say about these cases? And what does the order list not granting or denying, but potentially relisting these cases, what does that mean for the outcome of these cases? Well, essentially that's because all Supreme Court analytics and tracking on prior cases show that a case has a higher odds of being granted review by the Supreme Court if it's relisted only one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of all petitions that were relisted just one time were eventually granted review, and between 66% and 75% of all cases that were eventually granted cert were relisted at least one time. So all the data shows that a case being relisted just one time means that it has a far better chance of being granted review by the Supreme Court. But the data also shows that the more times a case is relisted, if there's multiple relists, that means that it kind of goes down in the odds of being granted review. The more times that it's relisted, the chances go down and down for it to be granted review by the Supreme Court. And so that means this could be a bad sign because these cases have now been relisted, I believe, 4 times. Multiple relists often indicates that the case is going to be denied review by the Supreme Court, and that maybe one or more of the justices is going to write a dissent in that denial of the case. So you may be asking us, where does this data and where do these developments actually leave us in these cases? Now, the first kind of domino fell with the Gray versus Jennings case being denied by the Supreme Court back on January 10th after that conference. However, since the Supreme Court decided to not outright deny the review of the Snope case and the Ocean State Tactical case, that kind of left everybody with hopes and kind of scratching our heads about why they dismissed or denied review of the Gray versus Jennings case, but then kept these 2 cases and are now relisting them multiple times. However, now with the multiple relists, the odds are that the Supreme Court is likely going to deny review of these cases. And the odds are that the multiple relist is likely a product of maybe a dissent being written by someone like Justice Thomas or Alito, who are unhappy with these cases being denied. And that's happened before, where we've seen a Second Amendment case be denied by the Supreme Court, and then you got a dissenting, opinion by Thomas and Alito saying that, you're treating the Second Amendment as a second-class right. And I would suspect if that happens here as well, you would get a dissent from either Thomas or Alito. Now, that's not to say that this is 100% what is actually going to happen. There is always an outside chance that the multiple relists is actually a product of heightened interest in these cases. We saw, very controversial cases like the Dobbs case dealing with abortion get multiple relists. And then also when it comes to the two-way context, for example, the most recent landmark Second Amendment case, New York State Rifle and Pistol Association versus Bruen, that case was relisted for conference 4 times before it was granted review by the Supreme Court and then ultimately was heard and decided. The Cargill bump stock challenge was relisted 4 times before it was granted review by the Supreme Court. So if you're looking at some of the other Second Amendment cases, they faced similar multiple relists 4 times or more before the Supreme Court actually granted review to those cases. So anyone saying that these cases are 100% done because they've been relisted, 3 or 4 times, they're not actually looking at the data and looking at the history or the prior Second Amendment cases that were relisted multiple times. The odds are that it's not looking great for these cases. It's not a great sign, but it's also not 100% sure that these cases are now going to be denied, review by the Supreme Court. We've seen, again, Bruen, Cargill, and other high-profile cases be relisted, 4, 5, 6, 7 times actually before they're granted review by the Supreme Court. The one thing that we can be certain of right now is that these cases will not be heard and decided by the Supreme Court this actual term. But if you are asking me what my gut feeling is, it's kind of telling me that it's likely going to be a denial in these cases, and then you're going to get a dissent from Thomas or Alito saying, the other justices are not, actually adhering to the Second Amendment. They don't want to address this issue. and maybe also some shots at, the Fourth Circuit and then other district courts and other circuit courts for not faithfully applying Bruen when it comes to things like rifles and magazines. So these cases are still in a very critical stage. We're going to keep our eyes on these to see what the Supreme Court does. Again, not a great sign, but also, there's still hope in these cases. You can still kind of hold out hope, but my general feeling is that maybe we are facing now a denial of these cases. And as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this station was built by Armed Scholars, and this station will be maintained by Armed Scholars.